Good morning, everybody. On behalf of the team here at ARAG and also the team at Stephensons today, a very, very warm welcome to you all to the second of our Talk to the Expert series. This one obviously focusing on care, and I do hope you are all keeping safe and well during this time. So here's the agenda. Obviously a very brief intro from me, and then we'll hand over to Julie finally to look at contract and debt recovery and how that's panning out in the care sector at present.
Morning everyone. My name is Julie Hunter. I'm a commercial litigation specialist and responsible for the debt recovery team at Stephensons. I am conscious of time and I'm just going to run through for you a few basic but fundamental points that you need to bear in mind in dealing with your credit control processes and general debt recovery. So starting off with the crucially important issue first. It's so important that you document who is responsible to pay your care home fees. If you have a local authority client, that's generally well documented and you'll know who's going to pay your fee and when. But the difficulties arise when your resident is a private payer or has agreed to pay top-ups with a local authority contract. And it's these particular cases that you need to be concerned about and that I just want to cover some basic points to help you with today. So if you just move on to the next slide, please, Hannah. The main point to make here is that it is so important that you have a written contract which clearly documents who is liable to pay your fees, what those fees will be. If there's top-ups, then what those top-ups are, how much they are. If you're going to review your fees regularly, you need to make that quite clear in the contract that you reserve the right to do so and that you'll give notice as to what the reviewed fees are to give people time to prepare for that. But the fundamental point is you have to, in order to ensure that you can properly recover your fees, a written contract clearly evidencing what's to be paid and who's paying them is crucial. An agreement in writing is obviously the best form of contract in order to be able to enforce it, and it should be clear as to who's paying, what they're paying, and signed and dated if possible. But it doesn't necessarily have to be a formal written document. A letter will do, even an email from the payer will be sufficient. But your best prospect of recovery and enforcing a debt is to have a written contract signed by the person that's paying it. Now that may be the resident, it may be the power of attorney over the resident, or it may be a family member. Just to illustrate how important it is and how difficult it can sometimes be to enforce fees recovery if you don't have an agreement in writing. I've currently got a case where there was a resident in a nursing home and she was there for about 4 or 5 years. At the outset, her son signed a contract agreeing to make payment, and he did so for 4 or 5 years. Unfortunately, he then died. The grandson telephoned the care home and said, "I'll take over responsibility and I'll pay the fees." But he didn't make any payment at all. Nothing was put in writing. Eventually, the resident gave notice and left the care home with 2 or 3 months outstanding fees unpaid. So the care home's now in a situation where it's trying to enforce recovery of its fees for 2 or 3 months with no contract signed by anybody, still living. So they have to look to either the son's estate, which means it's going to take some time to recover it, or the resident, who obviously received the services and therefore is liable to pay, or the grandson, who promised to pay but is now denying that he did so. So the care home's in a situation now where they have to take legal action against both the resident and the grandson in order to try to recover their fees. Obviously, that all could have been avoided had they simply got the grandson to confirm in writing his responsibility for paying the fees. So it illustrates how a simple request to put something in writing can solve an awful lot of problems in the future. So next slide, please, Hannah. So in terms of credit control, and this is pre-debt recovery, best practice is very, very simple. First thing to make sure is that you keep up-to-date contract information of the person responsible for paying your fees. So you need to make sure that you regularly check with that person that you've got the correct address, email address, telephone number, so that if they suddenly move and decide not to pay you anymore, you've got that information on and can get in touch with them. So I would recommend that a review takes place every 12 months or so, just to make sure that you know that you've got the right up-to-date information for people. And they will often move without telling you. Secondly, act promptly. If you find that your invoices for a month or so haven't been paid, move quickly to address that. The earlier you make your claim, the more chance you've got of successfully recovering your debt. So always act promptly. I would suggest both calling and writing. A telephone call to a payer who hasn't paid for a month or two might just be enough for you to identify that there's been a particular problem, that payments will recommence, so that you can be satisfied that you are going to be paid. But if a debtor is ignoring you, write to them, setting out clearly these fees need to be paid, because if they don't, further action will follow. You'll also find that it would be useful for you to offer various ways to make payment. So if you provide your bank account details so they can easily transfer payment, if you give them the option to pay by credit card, or even say that you'll accept a cheque as a last resort. But if you give them various ways to pay, it's more difficult for them to avoid payment. So the basic principle is act promptly, get in touch with people as soon as invoices fall into arrears, call and write. If you're not getting any response back, then you need to start looking at taking a more robust approach. So you might start with a gentle email or gentle letter of reminder, just that here's a copy of the invoice which is outstanding, can you please make payment? And if you're not met with any response, then a firmer letter or a firmer email saying, we need to address this because we don't want to have to escalate the matter. And if you're still not getting a response, then you need to look at taking a far more formal approach. So can we move to the next slide, please? If you're finding that attempts at communication aren't producing a response and payment, then you need to be looking at taking a far more firm and robust approach. Debtors fall into two categories, those that can't pay and those that won't pay. Can't pay debtors may suddenly find themselves in financial difficulties. These are obviously difficult times for everybody. We are moving into a recession, which is going to make it much more difficult for people to recover their debts. It also means that people will not pay unless they absolutely have to. So can't pay debtors will often be embarrassed about the fact that they're no longer able to pay and will try and bury their head in the sand, hoping that something will come up. Won't pay debtors will not pay you unless you absolutely force them to. And in that case, those people that shout the loudest and act in a far more robust manner are more likely to receive payment. So it's often difficult, but you can generally tell whether your debtor is a can't pay or a won't pay. Can't pay debtors will be amenable to entering into payment plans. So it's important here to be flexible. If somebody doesn't have the money, you're not going to get the payment. And so you need to recognise that and work with the debtors to try to flexibly arrange a plan that will eventually get you your money back, even though it will take some time. So it's sometimes a good idea to agree to take payment of a reduced amount over a longer period of time. And if you're able to do that, I would recommend very strongly that you put that agreement in writing, because that gives you a second layer of a new contract with this debtor saying, in respect of this debt, I will make payment to you of this amount over this period of time. And that will be enforceable as a contract. So if you didn't have it in writing to start with, you would then have a payment plan which you'd be able to enforce. Won't pay debtors tend not to pay until the very last minute. And so in these cases, you would need to issue a final demand. Typically, a very strongly worded letter saying that if the debt isn't paid, you're going to pass it on to your solicitors or debt recovery agents, will sometimes produce payments. Again, with all of these demands, send copies of your details of your bank account so that there can be no excuse about not making payments. But a final demand needs to be robust. Make it clear that it's a final demand and that if the debt isn't paid, you'll be passing the matter on to a recovery agent. It's often at this point that won't pay debtors will raise a dispute and say they're not making payment because, for example, you haven't provided the services that you were going to provide, or you've increased the weekly or monthly fees without telling them. These disputes should be addressed. You need to look at them and consider, do they have a point? Are they right? Do I need to make an offer or perhaps a small discount in order to reach final agreement to pay a certain sum? That will get you your money back without any further trouble. But apart from anything else, if the matter is eventually litigated, having addressed disputes at an early stage is going to put you in good stead with the court, who will recognise that you've made every effort to reach an amicable resolution with the debtor without recourse to court proceedings. And the debtor is going to find it far more difficult to argue any case in court if you've already addressed the disputes. But if you can't reach a final agreement with them and still no payments made, you then need to look at court proceedings. Now, if you're referring the matter to a lawyer or a debt recovery agent, before we can issue court proceedings, we have to issue a formal letter before action, which is compliant with the Civil Procedure Rules Pre-Action Protocol. Now, letters before action to an individual, as opposed to a corporate debtor, have to give these debtors 30 days from the date of that letter to make payment before you can issue proceedings. So you need to build into your time frame for referring cases the fact that another 30 days is going to pass after that formal letter has been sent. The other thing to remember about court action is that a court can only order a debtor to pay you a certain amount of money on a particular date. It can't force the payment. It can't force somebody to make a transfer into your bank account. A county court judgment is merely an order requiring one person to pay another a certain sum of money. You'd have to take enforcement proceedings if that county court judgment isn't paid. And this comes back to the point that I was making earlier about the importance of having the contact details, the debtors available to you and up to date. Because if you've got a judgment and you don't know where the debtor is, it's going to be very difficult to enforce it. But if you know where they're living or you've got email or contact details, then that judgment can be far more easily enforced. So just turning to the last slide, in summary, crucially document the terms that you agree. At the outset, make sure you've got something in writing confirming who is going to pay your fees, how much they'll be, when they're due. Act promptly. Always make sure that you follow up responses from debtors. Keep a diary note to make sure that you're chasing up invoices on a regular basis. Offer payment options. Flexible payment plans are far more likely to achieve the end result which you're looking for than a more strict approach of requiring full payment by a certain date, which may get you nothing back. But fundamentally, keep the pressure on, because the more you press the payment, the more likely it is that you'll get it. So I'll whiz through that because I'm conscious of time, but I'll hand you back, I think, to Chris now. Thanks.